Hi, my name is Kylie, and in today's video, we are going to be looking at a legal conflict between two countries, Aramika and Botuna, who had entered into a bilateral treaty to build and manage a shared dam. 10 years after signing, Aramika decides to suspend the treaty on its own, claiming that Botuna seriously violated the agreement by not sticking to environmental protections. Botuna, however, denies this accusation and argues that the environmental conditions have changed due to climate change and relies on the principle of rebus sic stantibus, a fundamental change of circumstances. Botuna also refers to a UN General Assembly resolution that recognizes access to clean water as a jus cogens norm. So, this has raised several important legal questions. Did Aramika have the legal right under the Vienna Convention on the Law of Treaties, or VCLT, to suspend the treaty unilaterally? Can environmental standards evolve to become jus cogens norms? And how do principles such as pacta sunt servanda, or treaties must be kept, material breach, and jus cogens interact when it comes to treaty obligations? So, for us to properly understand this case, it's important to break down several key legal principles from the VCLT. First, the Pacta Sunt Servanda, which is under Article 26. This is a core rule of a treaty law, which means that all treaties must be carried out in good faith by the parties involved. Second, material breach, which is under Article 60. If one party seriously violates the treaty, especially if it affects the essential purpose of the agreement, the other party is allowed to suspend or even end the treaty. Next is rebus sic stantibus, which is Article 62. This principle allows a state to withdraw from a treaty if there has been a fundamental change in circumstances that the parties did not foresee and that affects the treaty's original purpose. We can also look at jus cogens. These are higher ranking, non negotiable norms of international law, like the prohibition of torture or genocide. No treaty can override them, and if a treaty clashes with jus cogens, it can become void. And dispute resolution procedures, which is under Article 66. It outlines how treaty disputes, especially those involving jus cogens, should ideally be resolved through legal channels such as a judicial settlement, arbitration, or conciliation. Now, we're going to be looking at the issue of Aramika. So, Aramika argues that its suspension of the treaty is valid under Article 60 of the VCLT, claims that Botuna committed a material breach by not following the agreed environmental safeguards. But according to the ICJ's decision in Hungary and Slovakia, a breach can only be considered material if it significantly alters the position of the other party. So, Aramika would need to show that Botuna's failure to act seriously endangered the dam project or its core objectives. Now, we're going to be looking at the issue of Aramika. So, Aramika argues that its suspension of the treaty is valid under Article 60 of the VCLT, claims that Botuna committed a material breach by not following the agreed environmental safeguards. But according to the ICJ's decision in Hungary and Slovakia, a breach can only be considered material if it significantly alters the position of the other party. So, Aramika would need to show that Botuna's failure to act seriously endangered the dam project or its core objectives. Another case we can look at is France and United States 1978. This case also supports the idea that a treaty can be suspended in response to a material breach. However, this right isn't automatic. The suspension must be done in good faith, proportionate, and follow the correct procedural steps. If Aramika suspended the whole treaty without trying to engage in a dialogue, or if the breach wasn't serious enough, its actions could be considered disproportionate and challenged as excessive. And finally, under Article 66 of the VCLT, if Aramika and Botuna could not agree on whether a treaty can be suspended and diplomatic talks break down, then either state can refer to the matter to a dispute settlement. Article 65 also requires that Aramika formally notify Botuna if its intention to suspend the treaty and allow a reasonable time for response. If Aramika skips these steps, the suspension could be procedurally invalid, even if Botuna was actually in a breach. Now, we're going to be talking about the issue of Botuna. So, in response, Botuna relies on the principle of rebus sic stantibus, arguing that environmental conditions have changed so significantly that the original safeguards in the treaty are no longer practical. However, under Article 62 of the VCLT, the change must be unforeseen and fundamental, not just inconvenient. We can look at the Gapsikovo case. The ICJ made it very clear that environmental change alone isn't enough to justify to end a treaty unless it is completely undermines the original basis of the agreement. Similarly, in the fisheries case, which is UK and Iceland, the ICJ emphasized that a state can't just change or abandon the treaty's obligation on its own because of shifting circumstances. The bar is high. Political or scientific developments by themselves don't justify breaking legal commitment. Furthermore, Botuna also refers to a recent UN General Assembly resolution that recognizes access to clean water as a jus cogens norm. It argues that Aramika's diversion of water from the dam violates this fundamental right. While jus cogens norms do override treaty provisions, international law, and especially through ICJ decisions, and scholars like Erica de Wet suggested that very few environmental norms have reached that level. UN resolutions on their own are not legally binding unless they reflect widespread and consistent state recognition that the principle is fundamental and non derogable. But currently, there's no strong state practice or opinio juris to show that environmental protection or access to water has fully crystallized into a jus cogens. In Germany and Italy, the ICJ clarified that even widespread moral support isn't enough to create a jus cogens norms. There must be solid legal backing through state behavior and legal belief. Similarly, in the case of DRC and Rwanda, the court refuses to treat certain human rights provisions as a jus cogens, despite their global appeal, stressing that claims must be legally established, not just morally persuasive. As Hugo Grotius once said, if there's no higher law compelling to the state to keep its word, then there is no sufficient basis to give the contract which obligate the states to observe it. This highlights the challenge of relying solely on moral arguments in treaty law. However, that's exactly why the VCLT exists to turn states' consent into legally binding obligations that can be enforced through clear rules and procedures. So, to manage the legal and practical tensions in this dispute, I propose a few specific recommendations. First, Aramika and Botuna should consider setting up an independent environmental compliance body, possibly with oversight from a neutral third party. This body would be responsible for investigating and verifying any alleged breaches before either state decides to suspend the treaty. Doing so would improve transparency and help separate genuine environmental concerns from politically motivated claims. Second, the treaty should include a built-in review clause, such as a 5-year review cycle to reassess and update its environmental standards in line with the current scientific knowledge and climate technologies. This would allow the treaty to stay relevant over time, avoiding situations where outdated safeguards become a point of contention. Third, both state Aramika and Botuna needs to agree in advance to refer any future disputes to international legal bodies such as the ICJ or the Permanent Court of Arbitration before taking any steps like suspension. This will be in line with Article 66 of the VCLT, which promotes dispute resolutions through legal means where there's disagreement over suspension or termination. It would also discourage unilateral action and help maintain legal consistency. And lastly, to support the long-term development of environmental norms, State Aramika and Botuna could work together to promote a multilateral agreements or declarations that recognizes environmental rights, such as access to clean water. Over time, such efforts may contribute to elevating these rights into the status of jus cogens, especially if backed by consistent state practice and opinio juris. So, taken together, these recommendations aim to strike a fair balance between upholding treaty obligations and adapting to the evolving challenges of global environmental protection. So, in conclusion, Aramika's suspension of the treaty may be legally justified, but only if it can prove that Botuna's failure to follow environmental safeguard amounts to a material breach that strikes at the heart of the treaty's purpose. Even then, Aramika must meet the standards of proportionality and good faith. If acted prematurely or skipped diplomatic efforts, its legal position becomes much weaker. So, as for Botuna, well, its arguments reflect growing global concern for the environment. They face tough hurdles under current international law. The use of rebus sic stantibus is difficult to sustain as Article 62 of the VCLT sets a high bar. The change must be both fundamental and unforeseen. The ongoing climate crisis, though serious, has not yet been recognized as such in a legal sense. Similarly, Botuna's appeal to jus cogens, such as the right to clean water, remains aspirational. These norms may be gaining political support, but they haven't reached yet the binding legal status that allows them to override treaty obligations. And cases like Hungary and Slovakia, France and United States, Germany and Italy reminds us that procedure matters. Article 65 and 66 of the VCLT outlines a clear legal pathway for states to notify, respond to, and resolve treaty disputes. With skipping these steps, even with good intentions, can make an otherwise valid claim procedurally invalid. These cases highlights the urgent need for modern treaties to be more adaptable, to reflect environmental realities, and to ensure that legal safeguards against hasty, one-sided decisions. It also shows that the future of treaty law lies not only in the text of agreements, but in how we interpret and apply them in a rapidly changing world. Ultimately, this is a story about balancing state sovereignty with legal accountability, and about using international law not just to preserve order, but to respond meaningfully to global challenges like climate change. Thank you so much for watching, and I hope you have a deeper understanding of this topic. Thank you.